we have Michael Felling here. I don't know if you heard us.
Yes.
Yes.
I heard you pretty good. Everything's fine. And good morning, everybody. We have real Spanish sunshine today in Hamburg, but of course, I'm so sorry that I can't be with you in person today. But I'm grateful that I have the chance to deliver my talk this way.
So, Professor Felling, we are going to distribute the short resume that that you have done to us. We are going to do that in 1-2 minutes, but you can begin with your speech, and the public here is going to have this paper for you. Thanks a lot. So go ahead.
Okay. So my topic: regulatory strategies for the sharing economy, chances and limits of regulated self-regulation of digital platforms. New services in the so-called sharing or collaborative economy pose new regulatory challenges. According to the European Commission, the term refers, I quote, business models where activities are facilitated by collaborative internet platforms that an open marketplace for the temporary usage of goods or services often provided by private individuals. As intermediaries, such platforms have dramatically reduced transaction costs, so these services can now be offered not only by professional service providers, B2C, but also by peers on an occasional basis. Uber for transportation and Airbnb for short-time rental are the most prominent examples. It should be noted, however, that there are many more, including, for example, household, in particular cleaning services, and car sharing or pooling, which might be much more important in the future. There are many articles in law journals, papers, and even court rulings dealing with the question whether services like Uber or Airbnb comply with existing regulatory framework, which was in large part modeled with a view to the conventional economy rather than the internet-based sharing economy. In contrast, I would take a more general approach, combining legal and policy analysis with some basic economic categories, including behavioral law and economics. Although there is certainly no one-size-fits-all solution in dealing with the sharing economy, the characteristics such digital platforms allow to identify some overall recommendations for better regulation. The European Commission's communication on the collaborative economy from 2016 has a similar goal, and the same is true for some working papers at the national level, most importantly the 2016 report of the German Monopolies Commission. However, the European Commission mainly takes into consideration state regulation and self-regulation, and it does not take a clear stand, mostly giving only vague hints. And the German Monopolies Commission, as usual, argues very much in favor of deregulation in order to foster competition. Doing so, it only refers to regulatory goals without mapping out more concrete regulatory strategies. And it neglects important regulatory issues such as working conditions and biases in reputation systems. There has been a long-lasting debate among legal scholars in the field of administrative law, not only in Germany, whether under certain conditions, strategies of regulated self-regulation, also referred to as co-regulation, might be more effective and efficient than both traditional command and control and poor self-regulation. The sharing economy is increasingly diverse, complex, and dynamic. In addition, there's a strong information asymmetry between the owner of a platform and the public authorities. Therefore, some scholars act very much in favor of regulated self-regulation as, I quote, polycentric governance capable of bringing multiple actors to the table. In the light of big data, there's also the hope that technology can serve regulatory functions. However, from my point of view, it's not so simple. Within the broad category co-regulation, there are quite different varieties which put greater emphasis either on the regulatory responsibility of the state or on the leeway left to self-regulation. Furthermore, co-regulation can become too complex to handle properly. I start with a case for regulation. One can first identify several regulatory goals in the sharing economy. Negative externalities are well known and often addressed in the legal debates around transportation services like Uber and short-term rental services like Airbnb. For example, in transportation, there's the risk of reckless drivers and unsafe vehicles. Other concerns arise from the prospect of uninsured drivers. Regulation has to protect against such threats to health and safety. This is typically done by way of market access requirements for the service providers, that is, individual drivers. However, the question remains whether additional rules are necessary, specifically addressing the platform owner, in this case, for example, short-time rentals might distort the housing market by effectively taking private residential property from the regular market. This causes rising mortgages in some cities. There's a strong public interest for regulation to secure affordable housing. Some cities have imposed limits on short-term rentals by setting maximum rentals per year, or in Germany, by prohibiting the misappropriation of private housing space. And furthermore, there is the concern that sharing platforms could attain a dominant market position by using the power of network effects. And this poses a challenge not only to competition law. Last but not least, we should also mention tax law to raise state revenues in the public interest. This is about externalities. Now, consumer protection regulation to rectify information asymmetries is an even more challenging issue in the sharing economy. However, with an internet platform as intermediary, it is not even clear which side is in need of legal protection. Therefore, service providers, for example, drivers with Uber, are often able to prosumers. Because the platforms bring together not firms, but mainly peers, the two contracted parties typically do not know much about each other. The user, for example, does not know the individual safety risks associated with the Uber driver or the Airbnb property. Just the same is true vice versa. In a reputation system, which is often referred to as a means of consumer protection, consumers and service providers can give mutual ratings but cannot judge the validity of this system. Having control both over a myriad of data and over the algorithms gives the platform operator enormous power to push both the users and the service providers towards adopting a behavior most favorable for him. In this context, for example, search pricing in transportation is a hotly debated issue. And last but not least, there are severe privacy concerns. Sharing economy firms are in a position to collect much more personal data from both users and service providers than is needed to fulfill their core function of reducing searching costs and facilitating trust. We must be aware of the risk that they do commercially use and even sell the data in a similar way as it is reported on Facebook and Google. See, the platform economy also challenges the paradigms of traditional labor law. Platforms like Uber refer to their drivers as independent contractors, but it is less than clear whether in reality they might better be considered employees. At least the imbalance of power might be similar to traditional employment relationships. As far as people have to make a living by delivering such platform-driven services and are not only occasionally involved in such activities, they might need regulatory protection against an abuse of power on part of the dominated platform. Everybody agrees that there must be a regulatory level playing field to secure fair competition between new firms in the sharing economy and firms in the conventional economy. but it is much more complicated than it looks at first sight. First, it is not so easy to determine whether such firms compete on the same markets. For example, Uber competes in part with traditional taxi companies, Airbnb with traditional hotels. But on the supply side, there's a difference that the new sharing economy also attracts non-professional service providers. Nevertheless, on the demand side for the users of these services seem more or less interchangeable. However, as far as the sharing economy provides these services more efficiently, that is, by reducing transaction costs and improving the allocation of resources, it broadens the market because more consumers are able to afford such transportation or short-term rental services. Therefore, the idea of a level playing field must not be used to curb innovative services as far as they really offer better services and new income and job opportunities. Secondly, and even more importantly, the level playing field does not necessarily mean identical regulation. As far as the unique features of the platform economy pose new regulatory challenges, the regulatory framework must respond to this. Two strategies are possible. The regulation can be technologically neutral, so that it fits to services both of the conventional economy and of the sharing economy, and is also open as to cover future technological developments. The new European General Data Protection Regulation follows this strategy. There's a price to pay for this. The legal provisions become very abstract, even vague, which causes severe problems of interpretation. The opposite strategy tries to address the new challenges by legal rules which are narrowly tailored to the unique features of internet platforms as intermediaries. The most prominent example for this approach is the e-commerce directive, and as discussed, there might be a platform directive in the future. The task is now combining different regulatory strategies. Legal scholars and regulatory theory typically distinguish three modes of regulation: traditional command and control, self-regulation, and regulated self-regulation, also labeled co-regulation. However, these three categories are each not homogeneous, but cover quite distinct variations. The first, regulation by the state, be it on European or on a national level, also referred to as command and control, has a bad image if it comes to innovative and dynamic business ideas. The sharing economy is often said to be ill-suited for top-down regulation because the state has limited experience with these new business models and lacks reliable information about the internal operation of such platforms. The public authorities' lack of information may also give rise to severe enforcement problems. Furthermore, state law with general applicability might be not flexible enough and therefore stifle innovation. Nevertheless, state regulation is called for to secure legal certainty. For example, to draw a clear line between professional service delivery and non-professional participation on allocation rules. Furthermore, it is exactly the general applicability which makes strict and stable regulation by the state best suited to guarantee a level playing field. And this makes state law preferable if the matter is not too complex and the public interest and regulation is particularly strong. This applies, for example, to safety standards, and it is also true for rules against the misappropriation of housing space as a result of short-term rentals, and perhaps even for minimum labor standards for service providers formally acting as independent contractors. However, the real question, in my opinion, is in how far such regulation should only target the service providers or also the platform. Requirements of income tax law primarily addresses service providers. However, regulating only Uber's drivers or Airbnb's hosts causes serious enforcement problems. It is the platform provider who has much better access to the necessary information. So it seems to be more efficient from an economic point of view to delegate the enforcement responsibility from the state to the platform provider. For example, the legislator should oblige the platform to ensure that the service providers pay their taxes by deducting the tax from the earnings transferred to them. Furthermore, some German states, for example Hamburg, have ordered platform operators like Airbnb to inform the public authorities about service providers and short-term rentals so that the public authorities are able to enforce existing bans on misappropriation. German doctrine refers to this category as, a difficult German term, Indienstnahme Privater, which means engaging companies to take on state tasks. It has recently made an impressive legal career in some other sectors, most importantly in energy law. While this system can amount to an impairment of the constitutional right to freely exercise one's profession or the entrepreneurship according to the European Charter of Basic Rights, such can be justified as far as the regulated entities bear a special responsibility because they profit from the chosen business model too. This precondition is met in the sharing economy. Sharing platforms like Uber or Airbnb earn their money by charging a percentage from the revenues of their drivers or flat owners respectively. According to some legal scholars, it would be problematic to impose duties upon the platform providers which amount to a responsibility to monitor the stored data of the service providers to detect illegal behavior. This would be correct if such platforms were within the hosting privilege of Article 14 and 15 of the e-commerce directive. However, this liability from monitoring duties does only apply when the platform provider has not played an active role of such a kind as to give knowledge of or control over the data stored. This must be judged not in general, but with regard to the specific setting in question. As an overall tendency, there is some reason to believe that many sharing platform providers are so closely linked to the provision of the real-world services that they are not limited to a more passive mode of service. This is true, it will only be a matter of proportionality in how far national law could delegate monitoring obligations to the platform providers. Second, poor self-regulation should only serve as a supplement. Self-regulation of the platform providers is the dominant mode of regulation up to the present date. The platforms determine the terms and conditions of their intermediary functions and define online and offline standards of behavior both for the service providers and for the customers. Reputational systems with ratings and reviews by both customers and service providers are currently the most important form of self-regulation sharing platforms. If certain conditions are met, self-regulation can be a better, that is more flexible and cheaper method of solving the problems that conventional state regulation. However, isolated self-regulation often lacks transparency and fails to account for the interests of actors other than the platforms themselves. The idea of a regulation 2.0 by a more or less self-regulatory algorithm might be fascinating, but such a purely self-regulatory approach risks increasing platform power, which is already a growing concern. Self-regulation does only work as far as the self-interest of the platform provider is, to a greater or lesser extent, in line with the public interest. Just as much as other companies, platform providers have a strong self-interest in a good image to attract service providers and customers. This seems to offer opportunities for self-regulation, in particular internal rating mechanisms and review options are genuine trust-enforcing mechanisms, which seem to further both the economic self-interest of the platform and the public interest in consumer protection. However, the image of lawfulness and service-oriented behavior is not necessarily identical with real consumer protection in complying with reasonable health and safety standards. With poor self-regulation, the information asymmetry is not challenged. Self-regulation must at least be supplemented by duties of the platform provider to provide information to the public authorities about the internal architecture of the platform and of the functioning of the algorithm. Not without reason, modern administrative law doctrine stresses the necessity of knowledge gathering as a precondition for effective state monitoring. In dealing with innovative services like the sharing economy, it can be useful to gather information about self-regulatory strategies in the first place in order to identify best practice solutions which might form a cornerstone of future regulation by public authorities. Third, there is an important but also limited role for regulated self-regulation. Regulated self-regulation, also named co-regulation, can combine the advantages of self-regulation, that is in particular flexibility and the platform provider's knowledge monopoly about the algorithm, and of state regulation, that is safeguarding consumer interest and public policy objectives, even if this is not completely in line with the platform provider's economic interests. However, there also are drawbacks. First, establishing an interplay between the regulator and the regulated is much more complicated than pure self-regulation or pure state regulation via command and control. And too much complexity of regulation is a severe obstacle to law enforcement. Secondly, combining both methods of regulation will not work if the gap between the interests involved is too large. With clear antagonistic interests, only strong state regulation will do the job. Thirdly, regulatory self-regulation on the level of a single firm, like Uber or Airbnb, can endanger a regulatory level playing field because it creates, at least possibly, different regulatory responsibilities for different market players. For judging the potential of regulated self-regulation, it is necessary to distinguish different ways of bringing elements of self-regulation and of state regulation together. With regard to co-regulation, some legal scholars predominantly refer to agreements between public authorities and sharing companies. For example, Airbnb and Amsterdam have signed a memorandum of understanding designed to promote responsible home sharing, but introduced time limits to ensure that entire home listings are not shared for more than 60 days a year. Such cooperative regulation might be sufficiently effective if they rely on enforceable contracts and not merely on non-binding gentlemen agreements. But there remains a severe competition problem as far as these agreements only cover one sharing company at a time and not all players on the market on, for example, short-term rentals. Coerced self-regulation happens if the platform formulates its own rules under the threat of governmental regulation which serves as a backstop if the self-regulation proves not to be successful. This, however, does not really solve the problem of information asymmetry because the legislator must be able to complete the regulatory framework. Thirdly, and most importantly, regulatory self-regulation can have the meaning that public authorities define the objectives to be achieved, giving the platform provider more or less scope for implementation. The European Commission has the same focus when defining co-regulation. If certain conditions are met, this seems to be the optimal way to recognize that the platform provider is in the best position to shape the internal operation of this platform. Data protection is a prominent case for such an approach. The European General Data Protection Regulation establishes only a broad framework of state regulation. To comply with the requirement of the freely given and informed consent according to Article 7 of the regulation, the company should establish a privacy policy by corresponding self-regulation. And finally, learning from the regulation of network industries, particular telecommunication, we can also identify several instruments to establish competition and special modes of regulated self-regulation. This can be shown by the example of universal service. In the context of Uber and other competitors on the taxi market, for example, public authorities might deem it necessary to guarantee a basic supply of such transportation services even in rural areas. Therefore, one could imagine a tendering competition comparable to the Universal Service Directive in telecommunications. And for financing such public services, a sort of universal service fee to be paid from all competitors above a certain market share threshold could be set into place. The element of self-regulation in the setting is that the company has to decide whether and in how far to take such tender. Now I proceed to my last chapter, the reputation systems of online platforms as a cornerstone of the sharing economy. The reputational mechanisms with numerical ratings and qualitative reviews, both of customers and of service providers, are central for the functioning of the sharing economy. Because the service is not provided by a renowned firm or brand, reputation systems are a major means to build trust between peers. If a service provider comes close to a 5-star rating, the maximum, the customer can seemingly be assured that the service provider will probably fulfill his contractual duties and will comply with applicable health and safety regulations, for instance. And the same might apply vice versa, that the customer has a very high rating and if there are no negative reviews about his or her behavior. Hence, such sharing platforms rating and review systems are often said to be effective in ensuring the quality of service as far as the typical consumer is able to evaluate. Thereby, such systems shall serve as an equivalent safeguards to the lack of traditional consumer protection law, which does not apply to contracts outside of conventional business relationships. Reputational systems are the most often cited example for the advantages of self-regulation. And here, the hope of a regulation by platform design becomes relevant. However, we still lack the necessary insight into the functioning of such rating mechanisms, and there are some shortcomings of pure self-regulation. Up to now, the reputation mechanism is within the platform's responsibility alone. There is no regulatory oversight by state authorities at all. The management of the reputation system, and even more the underlying algorithm, basically remain a black box. It's very difficult to assess the quality of the reputation system in detail. For example, it is not clear whether and under which circumstances platforms delete reviews because they are judged to be impertinent or even offending. Furthermore, we do not even know whether the platform eliminates some user-generated ratings due to statistical or other reasons and calculated the average rating, or when compiling the statistics summary of the service provider. There is a growing number of articles in the field of behavioral economics and psychology which cast some doubt on the validity of such rating systems. Many existing internet platforms, not only but including sharing platforms, have been shown to generate implausible distributions of star ratings that are unlikely to reflect the true quality. The literature has linked this to at least 4 underlying phenomena. herding behavior, whereby prior ratings subtly bias the evaluation of subsequent reviewers, underreporting of negative experiences because reviewers fear retaliatory negative reviews on platforms that allow and encourage two-sided reviewing, self-selection, where consumers who are a priori more attracted to a service are also more likely to use and review it, and most problematic, strategic manipulation of reviews undertaken by firms who seek to artificially brush up their online image. In the future, social bots might offer new opportunities to also manipulate a competitor's average rating on a large scale. An informed consumer might be able to overcome some, but certainly not all of these distortions. It is questionable whether the economic self-interest of the platform provider will lead to sufficient measures to gradually improve the reputational system and to fight manipulation. On the one hand, providers of sharing platforms will typically be interested in identifying and delisting or blocking service providers, customers, with the bad performance of illegal conduct, because such black sheep damage the reputation of the platform as well. On the other hand, sharing platforms might be even more interested in an overall high rating of their service providers, because this arguably encourages customers to use their platform instead of the services of competitors. Admittedly, sharing platform providers have taken some measures against the shortcomings listed above. For example, to avoid the underreporting of negative experiences out of fears of retaliatory negative reviews, Uber has changed its rating system in the US. The review is now only put online after the reciprocal review has been delivered to, or after a fixed period of time after which no reciprocal review is allowed anymore. However, the incentive to manipulate reviews, both by the platform itself and by its competitors, remains. It might even increase with growing competitive pressure. Because of these shortcomings, we should not exclusively rely on self-regulation to guarantee a functioning reputation. There is a need for safeguard consumer and public interest. As to that, one can think of different means for regulating the platform's rating and review system. First, sharing platforms could be ordered to provide detailed information about their rating mechanism to public authorities. Gathering this knowledge is a precondition for possible legislative and administrative action. Because of data protection regulations, a legal basis in a statute is necessary. Admittedly, even then, such a legal duty would not without problems, because disclosing internal operations of such software affects elemental business secrets of the sharing company. Because of this, precautionary measures must be taken to guarantee that only the state agency and under no circumstances competitors get to know the details of the algorithm. Secondly, the law could set minimal standards that a reputation mechanism has to meet. It would include the duty to correctly inform the service providers, the customers, and the public about the mode of operation of the reputation system. It would be up to the platform to shape this information in such a way that it is meaningful and as accurate as possible without giving away business secrets. This should enable consumers and contractors to better judge the validity of the rating system and to better correct for inherent biases. Thirdly, the platform must face the duty to delete or even correct wrong data within its reputation system on a notice and take down basis. This is already the law under the General Data Protection Regulation as far as personal data is affected, which is certainly true for qualitative reviews. Fourthly, and much more controversially, the provider of the sharing platform could also be forced to monitor the functioning of its rating system with a goal to detect manipulation from third parties. However, as already mentioned, such a duty would only be compatible with the e-commerce directive as far as in the reputation system the platform is not limited to a passive role of hosting reviews posted by others. Let me finish with only a few concluding remarks. New regulation adopted to new sharing business models does not automatically mean stricter regulation of the whole market on which such sharing companies act. The new challenges posed by the sharing economy give us the chance to overthink the adequate level of regulation for the conventional economy as well. And certainly, advocating a mixture of state regulation and regulated self-regulation should not amount to shut down innovative business models. We face the big challenge to develop updated regulatory framework that is sufficiently flexible to allow sharing platforms to operate while ensuring that service providers, users, and third parties, as well as other public interests, are adequately protected from harm that may arise from service providers through these platforms. And for this, we should also care about the fair distribution of any efficiency gains the sharing economy will hopefully produce in the future. Thank you very much.
So, Professor Felling, I don't know if you heard me.
Yes.
Yes.
Perfect.
So we don't have so much time for questions. Maybe only 5 minutes because we have now a coffee break. But I will take 1 or 2 questions, and I also wanted to make 2 questions myself. The first one, very quick questions. The first one is that as an expert in self-regulation, and as you have stated, I think it's more or less clear that not only in this realm but also in others, regulated self-regulation does work only when we have heavy regulation, real regulation from public powers. So at the end, in this field of the sharing economy, this trend, we can also see this trend. So what do you think that what we need at the end is a heavier regulation of this self-regulation, if I have understood correctly what you explained to us? And the second question would be that as long as data and data markets, I think that not only after what you said, but also after what we have heard here today and yesterday, data markets and data are the most important access barriers to competitors when you want to enter a market like this. So in order to strike a fairer balance between competitors, in order to try to diminish the importance of these entry barriers, how could we regulate this self-regulation of platforms? How could we, what kind of obligations could we introduce in this regulation? For instance, yesterday someone told here that it would be a good idea to create public obligations regarding data and the collection of data and the sharing of data, even between competitors. What do you think about that?
Yes, thank you very much. I will begin with the last question. Sharing of data between competitors is, I think, is a problematic issue because of business secrets. So I think there might be some sharing of data, but it can be only very, very limited. I think we should start with service providers and customers. They must be enabled by regulation, and I think that's already the case, mostly because of data protection law. They must be enabled that they can take their data from one platform to the other if they want to change the platform. That's the first issue. And of course, multi-homing must be allowed. I think that's possible. But an obligation for platforms in one market, for example, short-term rentals, to share all data, I think would be problematic business secrets. The second issue, of course, I very much argued in favor of stricter state regulation, because supplementary self-regulation will only work together with strict state regulation, and at least in part. So that's the general idea of regulated self-regulation. And I also, I only wanted to make clear that that must not have the result that these new services are no more possible. The state regulation should not have this effect. There might be some firms like Uber, which business models is very, very problematic, that they cannot comply with new standards or with enforcing of old standards, and they have to leave the market, at least in very many European jurisdictions. I think that's the case already. But I think there are many, many more sharing ideas in the future which might be much more reliable and much more productive than the ones we know now. At least in transportation, I very much hope for a lot of carpooling services, because they really have the potential to at least make some traffic problems in the cities less severe. So we need a regulatory framework which is sufficiently flexible to allow a lot of new sharing services to come up in the future. And we should not only look at some sharing companies today, which are at least very problematic.
Perfect. I have here another question. I don't know if you can hear the question, but if not, you say that to me and I will translate or repeat the question. So, please, can you introduce yourself for Professor Felling?
Yeah, I'm Victoria Descalva. I'm at the University of Twente. Thanks.
Do you hear the question? Do you hear Victoria or not?
It's a little bit difficult because...
so maybe it's better if you come here.
From far away in the room, so it's better.
No? So maybe it's better if...
okay. So, hi.
Well, that's me.
Yeah, and hi, that's me. No, so thanks for the fascinating talk. I guess my question was really, if I understood correctly, what you're suggesting is that the sharing economy would be regulated in a manner more or less similar to the way that network industries are regulated. I'm not sure if I got that correctly, but that was where I saw the talk going. But I was wondering if you could comment on the differences between the sharing economy and these network industries where we have a lot of experience already. Because the issue that I have is that a lot of attention is focused on Airbnb and Uber, and these are very well-known examples of the sharing economy. But there's also, I think the whole idea is that there's a lot of opportunities for decentralized service provision, so there could be also a lot of very small niche platforms, right? So you could have, I mean, there are always new sharing platforms popping up. So in that sense, I wonder how feasible it is to replicate the model that is for the network industries, where essentially you have several big providers which are regulated, and for the rest we make sure that the smaller providers have access rights and so on. With the sharing economy, which has specific issues, and I think you mostly focused on the quality issues and consumer protection, a bit competition, but it is a bit of a funny mix because you, as you also stated in the beginning, you also have the employment issues, of course, consumer protection, competition, increasingly fundamental rights. So it becomes a very complex mix of regulation. So in a way, my question is, to what extent do we need, can we apply the older model, or do we need something maybe a bit different? So that's my question essentially. And maybe one comment, so in discussing ratings, there's also the Article 5 of the proposed regulation, which also discusses ratings, and I was wondering if you think this is going in the right direction. So that's...
Thank you for the question. Well, I don't know, because...
Yes, you made a very, very important point. I skipped a little bit of my talk because of the time restraints. And I think there are some similarities to network industries, but only a few. I named two. The first one was the Universal Service ID, and the second one was about engaging private competitors to take on state tasks. I wanted to refer to energy law because in energy law, network operators are very much forced to take on state tasks when regulating the stability, but not only the stability, also the competition between renewable energies and other sources operating with the grid. So I think these two issues we can really can find parallels between network industries and the sharing economy regulation in the future. I do not think that there are many more, because the network effects, I think, are quite different. There are network effects with the sharing economy too, but the barriers to enter the market are much lower than they are in the network industries. And you don't have such a network monopoly as you can observe it, for example, in energy law or in railways. So there might be a tendency to monopolies in the sharing economy too, because a big sharing company with many service providers is much more attractive to consumers than, let's say, transportation sharing company with only 20 or 30 drivers. But these effects are less severe than in the network industries. So there should be a parallel with some issues, but this parallel between these two industries is limited.
So, yes, very quick, because we have to go to the coffee break.
You can also translate.
Yes,
My point is with energy, I'm not sure it's a good example, because precisely the fact that you have these very serious obligations on the providers is what is stopping this revolution in prosumerism, sharing energy, and so forth. So there's some literature developing on that, which is saying
the idea is that energy is maybe not a good example, because the heavy regulation
prevents the
is
development
in fact
of
impinging the development of new forms of producers and consumers using
sharing,
new forms and sharing,
energy.
etc.
So actually, the sharing economy in energy doesn't work because of the heavy regulation of the energy sector.
She said that in fact the sharing economy in the electricity markets doesn't work because of these heavy regulations that impinge consumers to share energy that are producing at home, etc.
Yeah.
Wow, that's maybe
I'm not so because of the new developments of blockchains and so on, but of course, right, there are differences, of course.
Yes. So thank you very much, Professor Felling. If we want to continue this discussion, we have, I don't know, email or WhatsApp, and I hope next time you will be able to come to Valencia, because as you know, we have
I'm very happy that I had the chance to do it this way, because otherwise I couldn't add very much plans and have a very good conference like again.
Thank you, and thank you very much for the effort. So, please, two organization questions which are important. Now we will go to the coffee break. It's exactly the same room that we have the coffee break yesterday. But please, we need you to say to us whether you are coming or not to the cultural events this afternoon and to the dinner this evening. We need a confirmation, because we have to phone the restaurant in order to say we are going to be 25 or 30 or 20, we don't know. We need the exact number, because if not, they have problems. And the second question is, please remember that we have to move to this room today, even though the schedule say that we are going to do the event in the Salón de Grados because of this problem with Michael Felling. And after coffee break, we are going to follow the schedule. So we will follow the conference in the Salón de Grados, which is on the ground floor. It's not difficult to find that, but it's important to go there. So, coffee break.